And we will just go on the record. This is ERD case number CR 2019000773. The complainant is Randall Stewart. The respondent is Langlade County. I'm Administrative Law Judge Stephanie Brown. It is Friday, August 27th, 2021 at approximately 9:30 a.m. We are here for a hearing on the merits of the complaint, which follows from a discrimination complaint that Mr. Stewart filed against the County of Langlade with the Equal Rights Division on March 25th, 2019, alleging discrimination on the basis of conviction record and arrest record. And after an investigation of that discrimination complaint, on September 30th, 2019, an investigator with the Equal Rights Division issued an initial determination finding that there was probable cause to believe that the County of Langlade may have violated the Wisconsin Fair Employment Law by refusing to hire or employ the complainant because of conviction record and because of arrest record. So based on that finding of probable cause, the hearing was certified to a hearing on the merits of the complaint, which is again why we're here today to hold the merits hearing. Before we begin, if I could get the parties' appearances, please, starting with the complainant.
Your Honor, the complainant, Randall Stewart, is here in person by video. So is his spouse, Shonda Stewart. Brian Formella, that is myself, is here as counsel for Randy.
And for the respondent.
Yeah, good morning, Judge. Attorney Oyvind Wistrom on behalf of Langlade County, and present with me is Sheriff Mark Weston.
All right. Attorney Formella, you said off the record that you wanted to make an opening statement. So if you want to begin with that, you can go ahead.
Yeah, thank you. And I suppose
I'm sorry. Before we do the opening statements, I guess I would ask for one thing. Shonda Stewart has been identified as a witness in this case. I think it'd be appropriate to, so we'd request that she be sequestered during these proceedings until she testifies.
Sure. What order do you have her testifying first, Mr. Formella?
Actually, I don't, Your Honor, but I do have, Shonda is not going to be testifying at all on any of the underlying issues with respect to allegations of discrimination or anything like that. She would be a damages witness only. And so because of that, I would ask that she be allowed to be present throughout with Mr. Stewart.
Is that something that we're even going to need to get into, to have the parties decided whether or not we're going to get into damages today? Because I know that was a question that came up during the pre-hearing earlier this week. There was some thought that maybe we would hold off on getting into damages, depending on what I found. If I found liability, then there might be a discussion between the attorneys to see if you could stipulate to damages. And if not, we could always have hold a short hearing to establish damages at that point.
Well, and I certainly leave that open to Your Honor. I think from our perspective, from my client's perspective, if we can get her done in terms of evidence being put in on that, that would be our bias. But we understand that the court, Your Honor, the tribunal makes the ultimate call on that.
Attorney Wistrom, I know you were I believe the attorney who brought that up during the pre-hearing. Are you prepared to present information about damages today?
Well, I think it is premature. As I mentioned in our pre-hearing, there hasn't been an opportunity to conduct discovery. This case was initially set for hearing on the merits back in April of 2020. It was delayed because of COVID, obviously. But Your Honor set a scheduling order that limited discovery and cut off discovery prior to that date. So there hasn't been any opportunity to get information about damages subsequent to that date. And I think it is premature. And in fact, the documents that Mr. Stewart, through his attorney, have produced are limited to, I think, a Schedule C for 1 year and a 1099 or a W-2 form for another year. There's no evidence, documentation relating to 2021 at all. So I think under the circumstances here, I think there's also significant prejudice to the county and to the respondent by virtue of this case being allowed to extend for an additional 1.5 years beyond when it initially should have been tried. So I think there's a number of damage issues that if this case is decided in the county's favor, we wouldn't need to get into. So I think from a lot of different reasons, it makes sense to hold off on trying the damage portion of it. We'll do liability today, and if liability is found, then we can stipulate, and if not, then forward with a hearing.
Well, I will note that typically if I find liability, I really don't make a specific award of damages anyway. So I know parties like to get into damages, but our awards are pretty general as to what the damages are. So I don't know that I'm too concerned about that. The other thing I will just note for the record, I mentioned last year that we could have done this virtual hearing well before today. So I just want to be clear that the parties were the ones that were continually telling me, I don't want to do a virtual hearing. We want to wait till it's in person. So I understand that this has been delayed. But last year already, I was telling the parties that, and as I stated during the pre-hearing, I've been doing virtual hearings for the past year. We could have gotten this done a lot sooner than today if the parties were willing to do a virtual hearing. So I just want to make that clear as well, that I know that there was some delay, but I was more than willing to get this scheduled and done well before today.
No, I understand that, Judge. I wasn't focusing my frustration on the process to you at all.
Attorney Formella, so if I'm understanding you correctly, Ms. Stewart would just be testifying about damages is there anything that she would actually need to testify to that Mr. Stewart couldn't testify to?
Just that in how they work their domestic partnership, I say respectfully of all partnerships in their that she's just the number cruncher. She's done the number crunching, and Randy has kind of let her be the number cruncher on it. So that's the reason why Shonda is better placed to provide information in that respect.
All right. Well, again, I don't know that we even need that testimony today. I think I will possibly just hold open the hearing for the damages portion again if I find that it's necessary. So given the fact that it doesn't sound like we're really going to need her testimony here today, I will allow her to stay in the room for the hearing as well. Anything else, Attorney Wistrom, that you wanted to bring up?
No.
Anything else? I'm sorry, go ahead. I cut you off.
No, I said, I'm sorry for interrupting you too, Mr. Formella, as you were starting your opening statement. I just wanted to make that objection before we move forward.
Thank you, Mr. Wistrom. And I'll try, thank you very much. Another matter, I guess I would ask though that there be a sequestration order with respect to the county witnesses on the liability phase.
Oh, and I had mentioned, that there was going to be sequestration. I typically sequester witnesses anyway. So, and as I looks to appear that there's nobody in the room with Attorney Wistrom right now that's going to be testifying on behalf of the respondent. And it looks like the door is closed, so I would imagine that nobody can hear what's going on in the hearing. Is that correct, Attorney Wistrom?
That is correct. And obviously the sheriff will testify that he's designated as the county's representative.
Right. And the respondent can always choose who they want as the county rep. So I can't control that one way or the other. But yeah, going forward, any of the other witnesses, and I'll remind them when they testify as well that they are not to discuss their testimony with anybody outside of after the hearing being completed. Anything else, Attorney Formella?
Kind of a superficial matter, Your Honor, but just to be clear, I could run up and get a suit jacket. I don't mean to be disrespectful to the tribunal or to any of the other parties, but if it's okay with you, if I just do the shirt and tie, and I am fully dressed otherwise.
It's fine. I do not require suit jackets or anything like that. So you are fine the way you are.
Grateful. Thank you. Nothing more.
All right. Then if you want to go ahead and start with your opening statement, you can go ahead and do so.
Thank you, Your Honor, and Mr. or Attorney Wistrom. The evidence will show that Mr. Stewart interviewed for a jail corrections officer position with Langlade County in October of 2018. The evidence will further show that during that segment of the interview, he was asked a very odd question. And that odd question, my term is odd. The question that the tribunal will likely hear about is at C10, it's going to be exhibit C10. You may hear me refer to it as question 7 throughout the day, throughout the testimony. The question that I think is out there that the county has relied on to try to make a claim of dishonesty is a question that reads like this. Is there anything that you would like to discuss now rather than have it discovered during our background check? There will be testimony and evidence that Mr. Stewart did his level best to interpret what that question meant. But that is what I'll call the question 7 issue that's before the tribunal today. The evidence will show that Mr. Stewart mentioned parking and registration violations, but not a 2010 disorderly conduct citation that apparently caused the county some concern. And apparently there will be testimony that required, or that it decided that Mr. Stewart was not being honest in response to that question 7 that I just read, when he failed to describe a disorderly conduct citation from 2010. The evidence will show that that 2010 citation did not result in a conviction whatsoever, but rather in a deferred prosecution arrangement, and then ultimately was dismissed without any sort of conviction. The evidence will further show that Mr. Stewart correctly answered all questions on a written application. That will be exhibit C9. The evidence will further show that in March of 2019, or several months later after this moment where question 7 was read, Langlade County and Sheriff Weston then recontacted Mr. Stewart for this correction officer position. It then made a conditional offer of employment to Mr. Stewart. That's exhibit C1 here. Langlade apparently then did something that it considers to be a background check, and then says, we ultimately believe the evidence will show it was troubled by this 2010 DC record of which did not result in a conviction, and then pulled the offer. I think the evidence will show that it pulled the offer without asking Mr. Stewart first, why didn't you mention anything about this contact, this DC event from 2010, when we asked you question 7 about whether there's anything more that you want us to know about, rather than it was just unilaterally the offer was pulled. The conditional offer was pulled. The evidence will show that Mr. Stewart was not told at the time of when question 7 was asked what was meant by a background check. And so because there was no definition given at that time in what was really a compound ambiguous question, we think will ultimately be a question for the court the tribunal to answer, that there, in this instance, is not good faith and honest position that it maintains, that it really thought that Mr. Stewart was being dishonest in answering that question 7. When Mr. Stewart, the evidence will further show that when Mr. Stewart pursued the reason why this conditional offer was being pulled, he wasn't at first told why. There was just no mention whatsoever. It was just a unilateral decision that the HR director told him. The evidence will further show that Mr. Stewart attempted to find out the real reason, and that the HR director then eventually said it was because of this DC event, this contact that you had. That was what caused the county concern, according to Ms. Verhagen, in March of 2019, after that offer had been pulled. He was told, the evidence will show, Mr. Stewart was told that he could reapply within a year or two from the time of that pulling of that offer. The evidence will show that unlike the cases that Langlade County has identified, there's been no falsification on a written application here whatsoever. And even though we would concede that falsification can occur both verbally, the setup of the question that they're using, we believe the evidence will show that that very question is a violation of the Wisconsin Fair Employment Act with respect to how information is elicited. And I'll get that into our case in chief as well. The bottom line is that the evidence will show that the question that the county kind of balked at or is using as a basis to claim dishonesty is an open-ended question. It's a compound question and an inherently ambiguous one, all of which goes to undercut the notion, significantly undercut the notion that there was dishonesty on the part of Mr. Stewart, and that what we really have here is an arrest record discrimination matter. At the end of the hearing, we'll be asking you to consider the question, if this question number 7 were put on a written job application, would that written job application withstand the scrutiny under the WFEA because of its ambiguity in terms of how Wisconsin considers the law of arrest and conviction record discrimination? We think the answer will be no. We'll argue that later at closing. That's what I have for my opening. Thank you, Your Honor.
Sure. Attorney Wistrom, did you want to make an opening statement?
Sure, just briefly, Judge. Thank
Sure.
you. Factually, the case, the parties are in agreement as to the basic essence of the facts. It's true that Mr. Stewart applied for a position as a corrections officer with Langlade County back in September of 2019. It's accurate that he completed an application. That application made it clear, and he signed the application indicating that any dishonesty either on the application or anything during the application process will be grounds for not being offered a position or rescinding an offer. There was then an interview in October of 2019 with the sheriff, chief deputy, John Schunke, who will testify, and Don Bergbauer, who was the jail administrator, and one county board member. You'll hear from 3 of the 4 individuals in that meeting. And the question that was posed, this question number 7, has been used by the department as really a litmus test for honesty. The person that's being hired is not being hired to work in a factory or as a laborer. They're being hired to be a law enforcement officer, corrections officer, where they're dealing with inmates and prison population, that honesty and integrity is absolutely paramount. So the question is asked, and it's asked in an open-ended question intentionally to solicit information. We want to know, the county wants to know, if there's anything out there that we're going to find when we do a background check on the individual. And it could relate to circumstances of leaving a job under bad circumstances. It could be actions with law enforcement. It could be a prior arrest or a citation such as the one that Mr. Stewart had. When the question was asked, he didn't ask any clarification. He didn't ask, what are you looking for? He answered the question, and he answered the question with no. And then he said, well, there's some traffic or registration issues. So the fact that he recognized the need to identify a traffic citation or a registration issue, we believe the evidence will show that he knew he had an obligation to disclose the disorderly conduct citation that he had in 2010. The fact that it was 8 or 9 years earlier doesn't change the analysis under the Wisconsin Fair Employment. Whether it was a week ago, a year ago, or 10 years ago, he had an obligation to disclose it. And so after that interview where he failed to disclose the disorderly conduct citation, he was put on a eligibility list for consideration in the future. Somebody else was given the job that he was interviewing for. But 4 months later, when there was an opening for a position, Mr. Stewart was contacted. He met with the sheriff. A conditional offer of employment was made. It was made clear by the sheriff during that meeting that he shouldn't quit his job if he has one, that this is a conditional offer, and you need to successfully pass a background check in order to get the position. The background check was done by the sheriff's office. consistent with past practice, and the background check revealed a disorderly conduct citation that was not disclosed by Mr. Stewart. It wasn't the disorderly conduct itself that was troubling, it was the fact that it wasn't disclosed by Mr. Stewart during the October 2019. Sheriff and Chief Deputy discussed the matter and agreed that based on the need of transparency and honesty and forthrighteousness when you're being interviewed, and his failure to disclose it, they felt he was not being honest, and on that basis, they rescinded the offer and moved forward. As far as the information that was provided, Ms. Verhagen will testify as to what information she did provide to Mr. Stewart and what is typically type of information she typically provides to a candidate who is not selected for a position. Ultimately, we believe all the evidence show that it was the dishonesty and his failure to disclose the disorderly conduct citation resulted in the county's decision to rescind the employment.
All right. Thank you both for making your opening statements. I think at this point we can start with testimony. Attorney Formella, who's going to be your first witness?
Yeah, I would, thank you, Your Honor. I would call Randall Stewart. But maybe before that, I would just ask the tribunal to take, would one say, administrative notice of a statute at this time before I begin in questioning.
What statute is that?
One is 111.335, paren 2, paren A. And the second one is 111.32, paren 1.
Those are parts of the Fair Employment Statute, correct?
They are, yeah. And so I'm not trying, yeah. And I would just read those into the record and ask that the tribunal take judicial notice of those.
Sure, you can go ahead and do that.
So asking the tribunal to take judicial notice of 111.335. I'm reading let me read all of 2A. Employment discrimination because of arrest record includes, but it's not limited to, requesting an applicant on an application form or otherwise to supply information regarding any arrest record of the individual except a record of a pending charge. That's the portion that I would ask the tribunal to note. I'm not going to continue reading an except proviso that goes to the end of that subsection just because I don't think it's pertinent here. And then the other section that I'd ask the tribunal to note is 111.32, paren 1, which defines arrest record. It states, quote, arrest record, close quote, includes, but it's not limited to, information indicating that an individual has been questioned, apprehended, taken into custody or detention, held for investigation, arrested, charged with, indicted, or tried for any felony, misdemeanor, or other offense pursuant to law enforcement or military authority. End of 111.32 sub 1. That's the extent of what I'm asking the tribunal to note administratively.
Sure. Attorney Wistrom, did you have any comments or response to his request?
No, not at this point. That's
All
fine.
right. So then I'll take judicial notice of those two statutes then. And then you said we're going to have Mr. Stewart start with his testimony. So Mr. Stewart, I do need to swear you in. If you could stand up and raise your right hand, please. Do you solemnly, sincerely, and truly declare and affirm that the testimony you will give in this matter is the truth, the whole truth, and nothing but the truth? Yeah, you're going to have to move that microphone closer to him because I didn't hear him at all, but I saw his lips move.
I do.
All right, thank you. You can sit down and you can put your hand down. And just for the record, please, Mr. Stewart, could you state your name and spell it for me, please?
Randall Stewart. It's spelled Randalstewart.
All right, Attorney Formello, whenever you're ready, you can go ahead and start with your questioning of the witness.
Thank you, Your Honor. Just doing a sound check. Does this seem sufficient for everyone, both you and Mr. Wistrom?
I can hear you fine. What about you guys, Attorney Wistrom?
Fine.
Okay.
Mr. Stewart, you've already given your full name. What is your occupation at this time?
Concrete laborer.
And what is your address at this time?
1513 Beatty Ave, Antigo, Wisconsin.
And turning your attention to October 2018, that time frame, did you apply for a position as a Langlade County Corrections Officer through the Langlade County Sheriff's Department?
Yes.
I'm going to ask to turn your attention, please, to R1. And what I've done here, Your Honor, is completed clean copies of the exhibits that both the county and I have submitted. So in looking at R1, it is something that is not marked up by me.
All right, and so I'm showing R1 on the screen right now. That's it looks to be appear to be the position description. Is that what everybody is looking at?
Yes.
Yeah.
Yes.
All right, go ahead then.
Yeah, thank you. My question, Mr. Stewart, is whether you ever received a copy of this position description, if you recall, as part of your application process for the corrections officer position.
Yes.
Do you know when you received it?
I cannot recall, no.
But you've seen that document before.
Yes.
And that's all that I have to ask you about on that for right now. Let me ask you, Mr. Stewart, why did you apply for the corrections officer position?
I thought it'd be a great job. I thought I'd be a great asset to the team, and it'd be a great opportunity, not only for me, but for my family as well.
Mr. Stewart, are you reading from something? If you're
No,
not,
no, I'm sorry. No,
I would just say that since we're done with that exhibit, let's close the
Okay.
binder up. And
Yep.
then when your attorney wants to ask you more questions about exhibits, we can look at those at that point.
Okay.
Thank you, Your Honor. You did interview for the corrections officer position in October 2018, correct?
Yes.
Who interviewed you at that time, if you recall, October 2018?
It's Mark Weston, Dan Bergbauer. That's all I can remember. I know that there's more people there, but those are the two that I can recall off the top of my head.
And they, roughly how long did the interview take, if you recall?
I believe half an hour or so.
Do you recall whether at any time during that interview, anyone in that interview said that you had a right to be free from discrimination on the basis of arrest or conviction record?
No.
Let me pull your attention now, please, to exhibit, what is our exhibit C10. I actually think C10 appears elsewhere, but in the binder here, that is our submissions. It's the clean copy of the Stewart exhibits. Let me take you to C10, please.
And is there a specific page that you're going to focus in on, Attorney Formel, or are we just starting on the first page? Because I believe that's the interview notes, correct?
Yeah, they say corrections officer interview panel, October 19. It looks like the interview notes. And then there's pre-printed questions on there.
Okay.
And the one that I'll ultimately, maybe even initially turn your attention to, Mr. Stewart, is the third physical page of Exhibit C10, something that at the bottom is marked as Stewart 0029. And you see something at the very top of that page that's denominated as number 7.
Yep.
And does that read, is there anything that you would like to discuss now rather than have it discovered during our background check?
Yes.
Was that read to you, or was that asked of you at this October interview?
Yes.
How did it come up that, was there any, by that I mean, let me strike that. Did anybody define for you what was meant by the phrase background check?
No.
Did anyone during that interview describe to you as to what it meant by something that you would like to discuss now rather than have it discovered?
No.
Is it your testimony that that question was read? Oh, let me ask you that. Was that question read with any explanation of your right to not have a prior arrest that is not pending be considered by law enforcement?
No.
Did you attempt to answer that question that was posed to you? That is to say, question number 7.
Yes.
And without looking at any of the notes there, I mean, how did you answer that question, if you recall?
I did say no. I said other than I have a parking ticket on there and the registration that I can think of off the top of my head.
And why did you speak to the registration matter and parking matter? Why did you offer those up?
That's all I could recall at that moment.
Did you think about, or were you aware about a 2010 disorderly conduct contact that you had with law enforcement at the time that you were being asked question number 7 in that October 2018 interview?
No.
Why not, if you know now?
At that point in time, that's all I could recall was the parking ticket and the registration. I'm sorry.
No,
are we
I
gonna-
was gonna let you finish. I mean,
Oh, no, that's,
I was gonna ask that, maybe go out of chronological order a little bit here, but just to kind of make sure we get into the record. Was there indeed a 2010 disorderly conduct citation that you were issued back in 2010?
no.
Was there any sort of disorderly conduct matter at all that you were that you were involved with in 2010?
Yes, I was told that I would have to appear in court to dispute it, but I never actually physically received a fine.
What happened to that? Testifying today, what happened to the matter, the disorderly conduct matter back in 2010, if you know today?
I appeared in court. We reached a plea deal where if I didn't receive any other fines or get in any other trouble for 90 days, that it would be expunged from my record.
And so far as you know, was that disorderly conduct matter expunged from your record?
Yes.
And
Objection,
did you have the
foundation.
understanding as
Just a
of
second. I think Mr. Wistrom made an objection.
Okay.
Could you go ahead, Attorney Wistrom?
Object to the foundation of the question as to whether or not the civil or the disorderly conduct citation had been expunged.
Do you want to respond, Attorney Formella?
I guess, I would concede that expunge has a significant, its own legal meaning. That doesn't matter here, so I can use another word rather than expunge and try my hand at that.
Sure, go ahead.
Yeah, so do you have well, you use the phrase expunge.
Well,
What do you mean by that?
I was told that it'd be removed from my record.
When you say it would be removed, what is the it that you're referring to?
The DC.
And when you say DC, you mean disorderly conduct?
Yes.
And if there's other evidence in here that shows that there may have been a citation issued to you, you wouldn't dispute that there may have been a citation issued to you that 2010 event, correct?
Yes.
The when you say it was told to you that it would not be on your record if you lived out 90 days or more, who told you that?
Objection leading, objection leading.
You can answer, go ahead.
The believe it was the judge that was there.
When you say I believe it was the judge that was there, where is the there that you're talking about?
In the courtroom. It was kind of an informal thing, really.
Tell me a little bit about the informality of the thing, really. What do you mean by that?
There was, I believe there was a desk and there was one person that was there that was, they were going through a list of similar cases. And, I'm sorry, I'm trying to fully recall because this was quite some time ago. There's other cases similar where they're trying to reach plea deals or reschedule for a further court case. But whoever that was there told me that I would have to stay out of trouble for 90 days and then it'd be removed from my record.
That
Objective basis of hearsay too, as far as testimony about what he was told by some unidentified individual at court would be considered hearsay.
I can allow hearsay, so I'll let the answer stand.
and so what you just described was an in-court experience with respect to this DC matter from 2010. Am I correct or incorrect about that?
Yes.
And your answer was yes. I just want to make sure.
Oh, you're correct. Yes.
The reason why I only say that is that we can't talk over each other. And so I just want to make sure that I
apologize.
Well, that's okay. But just let me finish, or I'll try to let you finish. Sometimes the fault may be mine that I jump you, but we'll try to just stay clean that way in terms of letting each other finish. Going back then to the time of the October 2018 interview, when that question 7 was posed to you, did anyone in that interview ask you about any pending arrests?
No.
Did they ask you about any arrests that were not pending other than question number 7?
No.
In asking you the content of question 7, did anyone say what they meant by the phrase, "Is there anything that you would like to discuss now"?
No.
What did you take that question to mean when you were answering it at that time?
Any fines or convictions that would show up on my record.
At the time that that is to say, the interviewers were asking you the content of question 7, did anyone on that interviewing group inform you about how broad or narrow background checks are conducted at Langlade County?
I was told that it's more in depth than a typical background check, but not to what extent.
Did they inform you how they define the phrase background check?
No.
Why didn't you ask them to define the phrase background check?
I thought there was a fairly, I perceived it to be a fairly standard definition just because of the other positions that I've held. I thought it was fairly,
And what do you, based on other positions that you held, what do you mean by what other positions that you've held have involved a background check?
I'm sorry, can you repeat that?
What other, you just described based on other positions you've held, you were making a certain assumption regarding what the phrase background check meant. I'm asking you, what other positions have you held?
I held a position at a lawn care place, at McDonald's, at Sotori Cheese, Line Tech, Dufek Sand and Gravel.
Of those other places, how many of them conducted background checks, if you know?
All of them.
And all of those places that you just identified were prior in time to your interviewing for the corrections officer position?
Yes.
And at any of those other places or positions that you held, was there, and then where there were background checks conducted, did any of them ever come back to discuss with you a DC disorderly conduct event from 2010?
No.
Did any of those other background checks regarding other positions that you held, was there anything adverse that came back in any of those other situations?
No.
Check the foundation. I don't
Yeah, I
think it
guess
knows the substance of all the background checks that were conducted by prospective employers.
that's what I was just going to say as well. Attorney Formella, can you ask him how he would know that?
Yeah, with respect, thank you, everybody. With respect to the background checks that we're going through from those other prior positions, how would you know that they conducted background
I
checks?
suppose it was presumed. I assumed it was pretty standard practice.
But you don't know one way or the other whether each of those other various positions did or did not conduct it.
I don't have proof that they did that, no.
When you say proof, you have and one way to prove something is in writing. Another way to prove something would be by what somebody told you, I suppose. Was there a basis of your understanding as to whether there was any prior positions conducted a background check?
Well, I suppose I've been told that, yeah, the background check came back clean. Other than that, I have no proof other than that, other than words.
You were asked on the application for whether you've been convicted of any felony. Do you recall that application?
Yes.
Try to. Pull out the red binder that is for the complainant's exhibits, and let me ask you to turn to tab C9. And looking at that, just for the record, that is base stamped as Stewart pages 22 through 26. Do you see that there? The answer is yes.
Oh, yes, yes.
The court is showing that on the WebEx screen there as well. What you're
The
looking
copy
at,
I have has handwriting on it. Am I correct, Attorney Formella? You said that your copy does not have handwriting, or does it have handwriting on it?
yeah,
Like up on the top here where it says correction officer, there's a date via phone call, let know, I think. I mean, is all that appearing on the copy he's got in front of him as well?
let me be doubly sure. The answer is yes. All that is, the
Okay.
handicap that you're saying is identical,
Okay.
so far as I can tell, to what the court is looking at.
Okay, that's fine. I just wanted confirmation of that because I know you had said earlier that you provided clean copies, and I wasn't sure when you meant clean copies if you meant completely clean. So I just wanted to make that clear.
No, that's fair enough. But I can represent as an officer of the court that what Mr. Stewart is looking at contains no formella handwritten.
Okay, that's fine. That's fine.
Looking at then C9, do you recognize what that document is, Mr. Stewart?
Yes,
What is that document?
an application.
And is that your application for the position of correction officer that is part of what we're looking at here at this time?
Yes,
I think at some point in here you've signed that. Well, there's looking at date stamp page or physical page 5, it's date stamp page 0026. It looks like it's got something called applicant signature and then a typing of Randall Stewart. Do you see that?
yep,
Looks like it's dated 9/22/2018. Do you see that too?
yep,
And on this form, we're asked, looking at the very first page, 2/3 of the way down, have you ever been convicted of a felony? And you see what you checked there, correct?
yes,
What did you check?
no,
That's a true answer, I'm taking it.
yes,
The next question says, have you ever been convicted of a misdemeanor crime of domestic violence? Do you see that question?
I do.
You check no there.
Yep,
correct? Is that a true and correct answer?
yes,
Is everything in this application, the written application, true and correct that you've submitted?
yes,
Now, if you strike that, you must have signed this. How did your the typewritten signature rather than a handwritten signature get on that document? I'm just curious.
I believe it's digitally.
It was digitally.
I
Did you
believe
do it
so.
digitally then? Or did-
I believe, yeah. Yes, yes,
And you must have signed it digitally on or about September 22nd, 2018, correct?
yes,
Going back to the interview of October 2018, where that question 7 was asked. So and you can close that
Yeah,
right now,
yeah.
just to be clear. Go ahead and close the book. And I don't think I even need to have you look at question 7 at this moment. Did the interviews ever ask you whether you had general contacts with law enforcement that did not result in a conviction?
no,
Did you ever pay any money? You paid money for, let me ask you this. Did you pay any money for what you described in your answer to question number 7 for a parking citation?
yes,
Did you pay money for a registration issue that you disclosed in response to question number 7?
yes.
How much money did you pay for each of those?
I believe the parking ticket was $25. And then through Langlade County, they offer it's a class that you can go through, and then what it is it informs you of all the driving laws and whatnot, and it instead of paying I believe the fine is $185. It'll lower that down to, I think it's $65 if I recall right.
We've already talked about this 2010 event, the disorderly conduct event. I take, well, did you or did you not pay any money for that matter?
I did not.
So going back to the question of number 7, why didn't you mention anything about a 2010 domestic conduct, disorderly conduct event? When you were asked the question you were asked at number 7.
The last I've had to worry about that is when I went into court to dispute that, and then have it being removed from my record. That was it.
Now, following that interview from October of 2018, what happened after that? Did you ever hear from the county again, is what I'm getting at?
No.
Well, fast forward me, at some point in time, you heard from them again, because like in 2019, correct?
I'm sorry. Can you go?
Yeah.
I feel like I lost you a little bit.
And I may not have been very clear. So in talking about that interview that happened at 2018, October 2018, I should probably ask a better question. How did that conclude, if you recall?
The interview itself?
The interview itself.
I thought it went pretty good.
And at the end of that interview, did you sign anything, if you recall?
Yes.
What did you sign at the end of that interview?
I believe the form is in the actual. I do not remember what number it is though.
Let me try to find that.
Okay.
I'm gonna find with you here. Let me turn your attention, please, to exhibit R6. And, I'm sorry.
Oh, you want
Go
me
to the
to-
red
okay,
binder
all right.
for our documents and turn your attention to R6. And again, that document seems to be dated 10/19/2018. Is that correct?
Yes.
Is that a copy of your signature there?
Yes.
Is that document copy which is contained in R6 a copy of what you were referring to that you signed at the end of that interview period on October, I think it was 2018?
Yes.
And then what happened after that? After that interview concluded, what did the county tell you whether you're going to be?
I was told that I would receive a phone call whether I did or did not get the position.
Did that ever happen?
Yes.
And what did you get?
I was told that I did not get the position, but I would be put on a eligibility list.
Who told you that, if you know?
I believe it was Tina Verhagen.
And then, if your understanding is that there was this period of time that you were on an eligibility list, is that right?
Yep.
What happened next that matters here with respect to the county then and the correction officer position?
Another position opened up, and then I was called to for a second interview.
Who called you for that second interview?
I'm trying to recall. That might have been Tina as well.
Did you actually attend a second interview?
Yes.
And when was that?
I'd have to refer to this to give you an exact date.
And when you say refer to this, do you mean
The clean notes here?
well, and when
or
you say
the-
the clean notes, I mean, there's a document within there that would refresh your memory, is that correct?
Yes, yes.
The document that would refresh your memory, is it the complaint that you submitted? in this matter?
I'm sorry, can you repeat that last
Yeah,
part?
is the document that would refresh your recollection with respect to the dates, the complaint that you submitted to the Equal Rights Division?
Yes.
Let me try to find that document and then if, pull your attention to that document. And you can start by getting out the red binder that has the C documents in there.
It might be complainants 4.
Yeah, thank you indeed, it is. So let me turn your attention to C-4. And the third
So we're
physical.
clear, I think this is an unsigned and unperfected charge. To me, it'd be better to use complainant exhibit 12, I think is the version that was signed and submitted as the final complaint.
Yeah,
Is that C7? And I know there's one in respondents as well, respondents 12.
yeah, I thank you, everybody. I'll note that it looks like C7 is indeed a signed iteration of a complaint. And so looking at, are you at tab C7?
Yes, I am.
And looking at tab C7, is that a true and correct copy so far as you know, the complaint that you submitted in this matter now before the tribunal?
Yes.
It's date signed March 20, 2019. Do you see that?
Yep.
And in looking at that document, does it refresh your memory as to who was present for a follow-up, what I'll call a follow-up interview in March of 2019?
Yes.
And when did that follow-up interview happen?
Um,
And take your time. You can. I'm looking.
yeah, I'm trying to. Yeah, March 1st, I believe. Yeah.
And that's what the documents.
Yes, yeah.
And so what happened at that March 1 interview, assuming that that was the date?
I was told pending background check and the testing, which is for hearing and etc. Pending that, I would be offered the position.
Who told you that?
Mark Weston.
Was that information that you received also prepared in a written letter to you?
I'm sorry, can you repeat that?
Yeah, was what Sheriff Weston said to you also reflected in a written letter to you dated March 1, 2019 as a conditional offer? And let me just ask you and pull that thought and just go to document C-1, please. And looking at C-1, Randy, does that appear to be a letter directed to you?
Yes.
What is, generally speaking, did you receive a copy of this letter at some point in time?
Yes.
And what, when did you receive a copy of this letter?
Right at that second interview, I believe this was.
And that was at the very bottom of C-1. Is that a true and correct copy of your signature indicating that you're accepting the conditional offer?
Yes.
And that's dated March 1, 2019. Is that correct?
Yes.
What was there anything substantive? Was there anything said at that March, what we think is a March 1, 2019 meeting about your rights to be free from discrimination based on an arrest or conviction record?
No.
Was there any follow-up with respect to the question 7 that had been posed to you back in October 2018?
No.
So after you signed or after you received this written conditional offer, what happened next?
I proceeded with some of the medical examinations, and then while I was doing so, I received a call that they said that they were retracting their offer of employment.
When did you receive a call saying that they were retracting their conditional offer?
To get an exact date, I'd have to refer back to the notes in there.
And I guess let's do that. What document did we use the last time? Was that C7?
Yes.
Yep. March 6th, I received the phone call.
And you're looking at your statement of discrimination narrative, is that correct?
Yes.
And without looking at that, to the extent that you're able to testify without looking at that, who contacted you?
Tina.
You say Tina, do you mean?
Tina Verhagen.
And what, if anything, did she say to you about the conditional offer being withdrawn?
She said that they were retracting it. I asked why, and she did not know why. She couldn't tell me at that time.
So she said she didn't know why, or she said, I'm sorry, say that again, please.
She did not know the reasoning why I was retracted the offer of employment at that time.
And did you ask her to try to find out, or did you not ask her to try?
I did, yes.
And so how did that phone conversation then end with Ms. Verhagen?
She said that she would look further into it. I think that was about it with that phone conversation.
At that phone conversation with Ms. Verhagen, did she mention anything about a disorderly conduct event from 2010?
Not at that time, no.
Did you ever yourself try to investigate why the county was apparently withdrawing this application?
I did.
The conditional offer, I should say.
I did.
And what did you do to follow up?
I tried to contact Tina Verhagen multiple times. I tried to contact Sheriff Mark Weston at his phone multiple times. Dan Bergbauer I tried to contact multiple times. And then the Boutnick I tried to contact as well.
What was that last name? I'm sorry, I didn't get that last name. What was that?
Detective Boutnick.
Okay. Do you know how to spell that person's name?
You want us to help out, Judge?
If you know, that'd be great. Yeah.
Why don't you do it, Sheriff?
It's Baucknecht.
Could you repeat that, please? Again, make sure I get it correct.
Baucknecht.
Mm-hmm.
Baucknecht.
Not in there.
All right. Thank you.
Did any of those individuals that you just mentioned, Mr. Stewart, get back to you?
No.
So what did you do next?
I went there in person.
You went there. Where is there?
The sheriff's office or the police department.
And when is it one and the same? I don't know, Antigo. It's different.
I believe it's one and the same.
Okay.
I'm I don't know the exact ins and outs of there, but
So when you went to the police department or the sheriff's department when nobody got back to you, what happened then?
I was told that I would have to speak to Tina Verhagen. Tina Verhagen pointed me back to contacting Mark Weston. And then I believe he said that he would, or that I would have to talk to Tina again.
Sheriff Weston said that to you?
at- uh, I cannot recall how that was brought to my attention.
But somehow it was your understanding that Ms. Verhagen would be a person that you would need to find out.
Yes, yes,
That you would need to contact for more information. correct?
yes.
And then what happened after you had that intermediate
At
information?
that time,
Wait till I finish,
oh,
please.
okay, I'm sorry.
And then go ahead. I'm finished, go ahead.
At that time, no one was available. I had to go in a separate time when she was available, and was told at that time that it was because of the disorderly conduct on my record.
And she said that to you?
Yes,
And tell me more, but was that in person that she said that to you?
yes.
And when did she say that to you?
To have an exact date, I would need to look at the,
Well, and let me take you there then. Please
Yeah.
go back to C7 and page stamp page 0019, if that'll refresh your recollection, is when you had that conversation with Ms. Verhagen.
um, yeah, that was March 8th.
Did,
I'm sorry, go ahead.
no, it was March 8th, that was the answer to my question. And then if you can testify, I mean, keep that open to that page, but
Okay,
if you can testify without looking, to the extent that you can testify without looking at that would be preferable. Let
okay.
me ask you a follow-up question then. Do you recall what, if anything, Ms. Verhagen said as to a reason why the conditional offer was being pulled?
She believed it was a judge of my character.
That's what Ms. Verhagen said?
I believe so, yes, yes.
Did you ask her what she meant by that?
No, I did not.
Did you, and what was the it that she believed was a judgment on your character? Did she say?
The disorderly conduct.
Did you try to explain to her the circumstances of that 2010 disorderly conduct?
I briefly went over it with her, yes, but she told me that I would have to try to contact Officer Mark Weston.
Hey, what did she say? Why would you have to contact, was it Sheriff Weston?
Yes.
What if anything did she say why you would need to do that?
She didn't really give me as a why too. She just said that would be the next thing that I would have to try to do.
At any time that you were contacting any officials following your learning of the pulling of that offer, did either Ms. Verhagen or Sheriff Weston or anyone ask you why you didn't bring up the DC matter from 2010 back in October 2018?
I was not asked that, no.
Did anybody indicate that if you could supply additional information, maybe they would reconsider whether they were going to pull the conditional offer?
No, but I was told by Tina to reapply in a couple years.
When did it's Tina Verhagen, right?
Yes.
When did Tina, and I don't mean to be disrespectful for purposes of the record, but just to be efficient, when did Tina tell you that you may be able to reapply in a couple of years?
At that time, at that conversation, the previous conversation we're talking about on March 8th.
There, and did she say 2 years from when?
And not really. She just said a couple years.
And I just want to ask you, Mr. Stewart, you previously testified that this was an in-person meeting you had with Tina, but it looks like in your complaint you said you talked to her on
I
March 8th by phone. So I just want to clarify that.
Yes, that it was over phone. I'm sorry. I miscalled,
Okay.
misrecalled.
There is something in the record that I want to try to find, and that is a letter that purports to be a pulling of the offer signed by Sheriff Weston. And as I'm looking for that, let me pull your attention to the other red book. That is the respondent's book. And ask you to turn your attention to tab R11. That, for purposes of the record, purports to be a letter from Mark Weston, the sheriff. It's addressed to Mr. Stewart, dated March 6th. Do you see at least a copy of what I'm talking about?
I do, yes.
And the address that's on there, it says 1513 BT Avenue, Antigo, 54409. Is that your address at least back in 2009?
Yes.
Excuse me, 2019?
Yes.
Did you receive this letter either by mail or by any other means prior to this litigation occurring?
I did not know.
When did you first see, if you recall, the content of this letter dated March 6th, that's exhibit R-11?
In the mix of the responses back and forth through the DWD.
Did you note anything in about this letter that struck you as unusual? In addition to the feature that you didn't receive it on or about March 6th, and that you first received it according to your testimony during the litigation phase of this matter. Was there anything else that drew your curiosity to the letter, that drew your interest to the letter?
Yes, it wasn't the position that I was that I applied for.
And what do you mean by that?
It's for a sheriff deputy position, and I applied for a corrections officer.
Other than Ms. Verhagen or Bettina telling you that something made you look like it was a poor judge of your character during that March 8th telephone call, did she or anyone else ever say anything more to you with respect to why the offer was being pulled?
No.
Did anyone give you a chance to explain what was of concern to them about what they felt was apparently made to look like you having a poor character?
No.
That's all I have at this time, Your Honor.
All right, Attorney Wistrom, do you have any cross?
I do, thank you.
Go ahead.
Mr. Stewart, you indicated that you applied for the position as a corrections officer back in September of 2018, correct?
Yes.
And you also testified that you had seen a copy of the job description that was marked as Respondent Exhibit 1. Do you recall whether that job description was attached or connected to the job posting for the position?
What exact form would that be?
If you want to look at Respondent Exhibit 1.
Um, I'm sorry, what was your question again about this?
Let me back up a little bit.
Okay.
Where did you see the posting for the corrections officer position that you applied for?
Online, I seen it.
And there was a job posting online with a description or summary of the job that you're applying for?
Yes.
And was this detailed job description part of the information that you had access to online when you applied?
Yes.
So you saw this job description before you interviewed for the position in October of 2019, correct?
Yes, I don't know if it was the complete description that is here, but I seen something very similar to this effect, yes.
And did you review that document at the time that you applied for the position?
Yes.
And do you understand that as a corrections officer, you'd be dealing and interacting with inmates housed in the county jail?
Yes.
And did you understand that you would be required to uphold judgments in the law?
Yes.
Did you understand that you would be exposed to certain temptations to show favoritism that could potentially provide a financial gain to yourself?
Yes.
Do you understand that honesty and integrity was a critically important position or critically important characteristics for this position?
Objection, the characterization of the question unless it's in the Exhibit 1 or Exhibit R1.
You can answer
I'm
the
asking his understanding of the position.
You can answer. Go ahead.
Yes, I believe, yes, honesty is a big part of that.
And integrity as well.
Yes.
And if you look at Exhibit 1, in the essential duties and responsibilities section, in the second paragraph, in the second sentence in the middle, it says, it is a business necessity that officers exhibit a history and characteristic of honesty, reliability, ability to manage personal finances, interpersonal skills, and integrity. Did I read that correctly?
I'm sorry, where are you finding that?
On Exhibit 1,
Yep.
there's about a third of the way down, it says essential duties and responsibilities, which is
Yep.
underlined. And then the second paragraph under that paragraph that starts, since corrections officers are required to uphold judgments of the law.
Yep.
Reading, it says, it is a business necessity that officers exhibit a history and characteristic of honesty, reliability, and then further down, integrity. Did I read that correctly?
Yes.
And did you understand that those essential duties and responsibilities at the time that you applied for the position?
Yes.
Now, if you want to flip to the next exhibit, which is Respondent Exhibit 2. Appears to be a resume. Is that in fact your resume?
Yes.
And did you submit this along with your application for employment that we have marked as Exhibit C9?
What
Yes.
exhibit? I'm sorry.
He asked if he included this resume with the application that's noted as C9.
Thank you. And is there a microphone that Mr. Wistrom is able to move a little more close to himself, please? Or maybe if there's not, then I'll do my level best on my end. Increase the volume.
Yeah, I don't believe there is.
Thank you.
Judge, are you having a hard time hearing me too?
You're quiet, but I can hear you.
Okay. Um, I think the microphone and camera is probably connected up here.
It is, because now you're
Uh,
really loud when you stood right up there.
I can scoot a little closer maybe. All right, so I think the question that was asked is whether or not respondent exhibit number 2 was submitted along with your application for employment.
Yes, yes.
And neither exhibit 2 nor complainant exhibit 9 shows any prior experience as a corrections officer, correct?
Correct.
Did you have any prior law enforcement experience at all prior to your application at Langlade County?
I did not know.
Was there anything other than your resume and the application that you submitted back in September of 2019?
I'm sorry, can you repeat that one more time?
Anything other than those 2 documents, respondent exhibit 2 and complainant exhibit 9, that you submitted as part of your application to the county?
No.
Now, if you want to turn to respondent exhibit 3, which I will represent to you is identical to complainant exhibit 9, other than this document is actually a 6-page document, which I think is the complete version of it. Complainant 9 only has 5 pages. The 6th page is blank, so it doesn't make much of a difference, but I just wanted to point that out because I believe, Judge, for your benefit, the last page of complainant for respondent exhibit 3 was inadvertently included as page 2, the complainant exhibit 10.
Yes, I see that here.
Page 2 of complainant exhibit 10 really doesn't belong in that packet.
Sure.
So turning your attention to respondent exhibit 3, which is the application that you completed, correct?
Yes.
And on page 5, second to last page, you there?
Yes. Believe so.
And on the bottom of 4 and onto the top of page 5 is an essay question that you were asked to answer, correct?
Oh. Maybe I'm not on the right page.
Can you kind of
So
see
look at
where
the
it's up on the
John, that's the
screen?
right one.
I think that's what you're
Oh, yeah.
looking at or trying to look at, Attorney Wisdom, right? The bottom of page 4 of the application onto the page 5 of the application.
Exactly.
Page performance.
Page 4. It starts
one
at the
there?
bottom. It says 6 general, and then it says please complete the essay question below and include with your application. And then
Yep.
it continues
Okay.
on to the last page.
Okay. Yep.
So the top of page 5 is in fact what you typed in as your answer to the 3 essay questions.
Okay.
And then below that, it is okay. That means yes, that's your writing, correct?
Yeah. Yes.
Below that, it says applicant, please read carefully and sign below. Do you see that?
Yes.
And then it said information provided and statements made as part of this application may be grounds for not employing you or for dismissing you after you begin work. All information and statements made are subject to verification. Did you read that when you applied?
Yes. Yes, I
And
did.
below that, it says all information provided and statements made by me as part of this application or as part of any additional information provided in support of this application are complete, correct, and true to the best of my knowledge. Did I read that correctly?
Yes,
And did you read that prior to signing this document?
I did.
And then below that, it says, I understand that if I am employed false information provided or false statements made as part of this application may be considered as cause for dismissal. Did I read that correctly?
Yes,
And did you read that prior to signing this on September 22nd?
I did.
Now, the handwriting on page 1 of Respondent Exhibit 3, that is not your handwriting, correct?
No.
You know whose handwriting it is?
No.
Now, following the submission of your application, did you receive an email communication from Tina Verhagen asking you to complete some essay questions or an additional essay question?
I can't recall if I did or did not receive an email from her.
So Exhibit 4, you want to look at Respondent Exhibit 4. It looks like on September 25th, Tina emailed you and said, "Hello, Mr. Stewart. Thank you for your application and interest in Langlade County. As part of the application, we require applicants to complete the 3 essay questions. Can you please answer these questions and email them to Tina or T. Verhagen and her email?" Do you see that?
Yep.
And then there's the 3 essay questions which were on the application. And then it looks like on September 29th, you submitted your response to the essay question. Do you see that?
Where are you seeing that? Is that the same page?
Top of page, Respondent Exhibit 4.
Oh, yep.
So can I take it from this that when you submitted your application initially, it was incomplete and did not have the essay answers completed, and that was added after the fact?
Objection, form of question.
You can answer, go ahead.
I'm sorry, can you repeat the question one more time?
So it looks like to me that the essay question that's being asked of you to be answered on September 25th, that you answered on September 29th, is the same essay question that is found on Respondent Exhibit 3, which is your application. So I'm trying to figure out, is it true that you didn't complete that as part of your initial application? And is that the reason why Tina Verhagen then followed up with you to ask you to complete and answer those essay questions?
Objection, characterization mischaracterizes the the physics of the original application.
You can answer the question.
To the best of my knowledge, I can't recall if it was before or after.
Do you recall specifically whether or not you answered the essay questions on Respondent Exhibit 3 before submitting that on July 22nd of 2018?
I recall answering them, I just cannot recall when.
So September 29th may have been the first time you answered the essay questions?
It may have.
I want to change focus a little bit and talk a bit about the disorderly conduct citation that you were issued in July of 2010. It's my understanding that you were in an altercation with your then girlfriend by the name of Jordan LeCue, is that correct?
Yes.
She apparently had pushed your motorcycle over, is that correct?
Yes.
Which resulted in some pushing or shoving between the two of you? Is that correct?
No.
Was there any physical contact either between you and your girlfriend at the time back on July 2nd of 2010?
From what I recall, there was she attempted physical contact, but I distanced myself from what I can recall of that.
Do you have a good recollection of what happened as part of that incident?
I I can remember bits and pieces of it, but it was, I mean, it was quite some time ago now.
So your testimony is that there was no physical contact either between, from you directed at her or from her directed at you?
Not that I can recall.
And was it your mother that called the police?
Yes.
And the police arrived on scene, correct?
Yep.
You remember how many officers were there?
At least two.
And those were from the,
I can't fully recall the number of officers that were there, no.
and Judge, if you want to take the screen down,
Sure.
let's see Mr. Stewart, thank you. So at least two, possibly more?
Yes.
And how long were the police present? This is at your residence, correct?
Yes.
Do you know how long they were present?
15, 20 minutes maybe?
And you were informed by the police that both you and your girlfriend would be issued disorderly conduct citations?
Yes.
And were you issued that citation on that day, or was that issued to you at a later point in time?
I don't know if it was actually issued to me at all. I was told that, or maybe I didn't. I might have received it in the mail. I don't believe I was issued a citation at that time.
But you were instructed, you received some type of information indicating that you could challenge the citation by going to court, correct?
Yes, yes.
And would that have been on the citation that you received?
I don't know if it was on the citation. I acquired information that I could dispute that.
And the citation, you recall whether or not there was a penalty or a fine that you were assessed as part of the citation that you were issued?
Objection, use of the phrase assessed is misleading.
You can answer the question.
Can you repeat the question?
When you were issued a citation, was there a fine on the citation that you received?
A fine amount, or
Yes, a monetary fine.
I believe so.
And was that monetary fine approximately $390?
Yes.
And your prior testimony was you didn't pay that fine, right?
Yes.
So you did go to court, and I think the records indicate that you went to court on July 27th of 2010. That sound right?
That sounds about correct.
Did you hire a lawyer to help you with this?
I did not.
So you went in by yourself?
Yes.
And was your girlfriend at the time also present with you?
I can't recall that.
And you indicated that something to the effect that if you didn't have any further issues for 90 days, the charges would be dismissed, or words to that effect.
Yes.
Was it 90 days or could it have been 6 months?
It may have been. I I I
Remember
could have
when-
sworn that it was 90 days though. It may have been 6 months, but as far as I can recall, I believe it was 90 days.
Do you remember the date in which the charges were allegedly dismissed or dropped?
I do not know.
Do you remember whether it was in 2010 or in 2011?
I can't recall that off the top of my head, no.
And in connection, when you went to court on July 27th and entered into this plea deal, you pled guilty to the charge of disorderly conduct, correct?
Yes. Yes.
And after the either 90 days or the 6 months lapsed, it was your understanding that the matter had been dropped or dismissed, correct?
Yes.
And did you kind of allow yourself to forget all about it after that?
Yes, that was the last I dealt with it, and that was the last I needed to worry about it.
So after you submitted your application to Langlade County, you were contacted and you were set up for an interview. I believe that happened on October 19th of 2018.
Yes.
And you testified that Mark Weston, and I think you said Dan Bergbauer was present.
I believe so.
Could it be Donald Bergbauer instead of Daniel?
Yes, yeah.
And then you remember whether John Shunk, the chief deputy, was also present?
He may have been there. I believe it was 4 people that were present at the interview.
And was there also a county board member supervisor who was present?
I can't recall that.
Was there a female who was present?
I can't recall that either.
Now, if you look at Respondent Exhibit 5, which are notes from the interview that was taken on October 19th. You see that?
Yes,
And you didn't take any notes during the interview, right? These are notes taken by somebody else.
correct.
And prior to Exhibit 6, there were, or question 7, there looks like 6 other questions that were asked of you before that, correct?
Correct.
And was it the sheriff that was asking all the questions?
I believe so.
And
I'm pretty sure, yes.
with respect to question number 7, the question that was asked was, is there anything that you would like to discuss now rather than having it discovered during our background check? That was the question that was asked of you, correct?
Correct.
And when that question was asked of you, you didn't express any confusion about the question, did you?
Slightly, only because I felt that I had nothing to hide.
Yeah. I think you testified earlier that you understood the question to mean that anything that would show up on your record is something that you had an obligation to disclose. Is that right?
Objection mischaracterizes the testimony.
Well, do you agree with that statement or not, Mr. Stewart?
I'm sorry, can you repeat the statement one more time?
Did you take that question to mean that you should disclose anything that would potentially show up on your record?
I took it to meaning that I tried to recall anything that I could at that moment.
And your testimony is that you had forgotten about the disorderly conduct citation and the deferred prosecution?
At that point in time, I did not think to bring it up because I recalled what I could off the top of my head.
Doesn't really answer the question. Did you remember it at the time? Or did you remember it, choose not to disclose it because you didn't think you had to?
At that time, I did not remember it, no.
And if you had remembered it, did you understand that you had an obligation to disclose it?
Objection to foundation.
You can answer the question.
Can you ask it one more time?
Yeah, is it possible to read that back, Judge, or don't we have that capability? We probably
I don't have that capability.
I'll do my best to rephrase it. So your testimony is you had forgotten about it. Was it your understanding that had you remembered the disorderly conduct citation, that you had an obligation to disclose it?
No. Had I recalled it, I would have mentioned it.
So the reason you didn't mention is because you forgot about it.
Yes, at that point in time, I did not recall that.
And if you had remembered it, you would have disclosed it.
Yes,
And you understood that that the county would be doing a detailed and thorough job or a thorough background check on you?
it was mentioned that it was more in-depth than a typical background check, but not to what extent.
And did you understand at the time that a position like this as a corrections officer, it was necessary to do a more thorough background check than perhaps a job as a laborer or working at McDonald's?
I could understand why they would do that, yes.
And you testify that you had applied for a lot of other jobs and that this prior issue didn't result in any loss or any jobs being rescinded, but you had never applied for any type of a law enforcement or corrections position in the past, correct?
Correct.
At the time you were asked that question, did you have an understanding as to whether or not your disorderly conduct citation would show up on your background check?
I'm sorry, can you repeat that one more time?
When you were asked the question, did you have an understanding as to whether or not the disorderly conduct citation would show up on your background check?
I didn't know if it would or would not.
But again, because you forgot, you didn't have the ability to analyze whether or not you had an obligation to disclose it. You simply forgot.
Yes.
Turning your attention to Respondent Exhibit 6, which I think is identical to Complainant Exhibit 11. Is that correct?
I believe I had already marked R6 is the copy they actually used before.
Okay, all right. And by signing this, did you understand, sir, that you were authorizing Langlade County to do a background check on you?
I'm sorry, where is,
Respondent 6, it's the authorization form.
oh, there's 6. Sorry, can you repeat the question now that I have that?
Yep. Did you understand that by signing this document, you were authorizing the county to do a thorough background check on you?
Yes.
And going back to the question that you were asked, the question number 7, when you were asked the question, I think you testified that you didn't ask for any clarification as to what the question was asking, correct?
I don't believe I asked that.
And your initial response to the question was simply no, right? And then you added, well, there's a parking and a registration issue that you had, correct?
Correct. I took a little bit of time to think about it. I responded no, and then I thought about it a little bit more just because I wanted to answer to the best of my ability. And then the parking ticket and the registration was the first thing that popped into my head, and I didn't think of anything other than that.
Would you agree that the disorderly conduct citation is a more serious offense than a parking ticket or a registration violation?
Objection. Objection mischaracterizes the evidence.
Well, I don't think he's asking about the evidence. I think he's just asking about your client's opinion about what he thinks. So you can answer the question.
Objection relevance, but I understand the court's ruling.
Sorry, can you repeat that one more time then?
Did you understand that the disorderly conduct citation that you were issued was more serious than a parking ticket or a parking registration violation?
Causing for speculation and irrelevant, but you can answer the question.
I
I've
don't,
already said you can answer, so go ahead.
okay. I don't know if my particular circumstance was more serious than that. I guess I believe that it would be slightly more.
Agree that the disorderly conduct would be slightly more serious than a traffic or a registration violation.
A typical one, yes. I don't know if my circumstance would be as serious as that.
When you say your circumstance, you're talking about the factual circumstances that led to the issuance of the citation itself?
Yes.
And did you understand, sir, that after your interview in October of 2019, that no background check was completed at that time?
Sorry, can you say that one more time?
Was it your understanding that no background check was completed after your interview in October of 2018?
To my understanding, yes. No background check was made.
And you were contacted by Tina Verhagen, I believe the date was October 24th of 2018, and you were informed that you were being placed on an eligibility list, correct?
Yes.
And were you informed that somebody else was being hired instead of you for the position?
I was.
You were then contacted in end of February for a second interview or a second meeting with the sheriff. Who else was present, if you remember, at the second meeting with the sheriff where the conditional offer of employment was?
I believe it was also Don Bergbauer may have been there. And I believe it was Boutnick that was there as well. I believe he was the one that took me down to get fingerprinted.
Is it possible that the chief deputy, John Schunk, was also present?
It's possible.
And was it your understanding that when that interview and when that offer was made, that a background check had not yet been completed?
Yes.
Because you were informed during the meeting on March 1, when you were made the conditional offer of employment, that the job was conditioned on a background check, correct?
Yes.
And did the sheriff tell you that words to the effect that you shouldn't quit your current job yet, that you should wait until the background check has been completed?
I believe he may have said something to that effect.
And were you still working actively as of March 1 of 2020?
Yes.
And where were you working at the time?
Satori Cheese.
And when did you quit your employment at Sartori Cheese?
I can't recall the exact date.
But you were notified then on on March 6th of 2019 that the offer of employment was being withdrawn, correct?
Yes,
Were you still working at Suntory Cheese as of March 6th of 2019?
I believe I was.
And you don't remember when you left employment there?
No.
Now, during your first conversation with Ms. Verhagen, I think it was your testimony that she simply told you that the offer was being withdrawn or rescinded, and that she didn't know the reason why it was being rescinded, or words to that effect?
Yes.
Did she mention anything about the disorderly conduct citation during that first conversation?
No.
Anything else you can recall about that first conversation that you haven't testified to yet?
No,
I'm going to object to the form of the question, because it gets into the same problem that I think the question of number 7 gets into. And it's just improper. Anything else more that you recall? If you ask a more specific question, you may get a more specific answer. Objection on the form of the question.
Yeah, you can rephrase the question.
Did Ms. Verhagen provide you any further information as far as the reason why the offer was being rescinded on March 6th, 2000?
I don't believe so, no.
I want to direct your attention to Respondent Exhibit 13. You there?
So response 13, is that right?
Yep.
Thank you. And you're
This one, right?
R13, looks like you're there.
Yep.
All right, are you there?
I am, yes.
Okay. Respondent Exhibit 13 is a letter from you to Carmen Clark, correct?
I'm sorry, can you repeat that?
This exhibit is a letter that you wrote to Carmen Clark, correct?
Yes. Yes.
And this was submitted to the Equal Rights Division in connection with the investigation of your ERD complaint?
Yes.
And did you type this yourself?
Yes.
Okay. On page 2 of this document, in the first paragraph, you write kind of sentence starts, when this charge was dismissed, I allowed myself to forget all about it. You see that?
I'm sorry, what page is that on?
Second page, about the 5th line down from the top.
5th line. Okay, yep.
Yep. And then a couple lines down, the last sentence of that paragraph says, I've not had to think about or reference the citation since it was dismissed, thus forgetting all about it until Tina Verhagen reminded me of it when she said it was the reason they were withdrawing the offer of employment on March 6th, 2019 via phone conversation. Did I read that correctly?
Yes, you did.
Is that an accurate statement?
Yes, I believe so.
So she did tell you the reason why they were withdrawing their offer on March 6th of 2019.
I'm sorry, it's just, it's been a couple years now. I'm trying to recall the exact conversation that was. she may have said something about, I know she said something about something that came back on the background check.
Which
But I
would have
don't
been
think,
sort
I
of-
don't think she, I don't know if she mentioned anything other than that.
So your testimony is that on March 6th, the first conversation, she did mention that something came back on the background check as the reason why you were not being moved forward in the process.
I believe so.
Did she mention the disorderly conduct citation that was discovered on your background?
I don't believe she said anything about a disorderly conduct. I
Did you,
believe she said something referring to the background check itself. And
you understand that when she said that to you on March 6th, that it was the disorderly conduct citation that you had forgotten about? That was what was discovered on your background check?
at that point in time, I don't. I'm sorry, can you repeat that one more time?
So on March 6th, when Tina
Yep.
Verhagen explained to you that something was found on your background check, did you have an understanding at that point in time that it was the disorderly conduct citation that was the reason your offer was being withdrawn?
Not at that point in time. Or I'm sorry, let me just review this real quick.
And I don't mean to
Yes.
rush you, Mr. Wistrom, but just so you guys know, Courtney Immig's been waiting in the room for about 30 minutes and I haven't brought her in yet. So do we have any idea about how much longer it's going to take to get through this witness, or should I bring her in just to let her know, like, to reconnect later?
Yeah, and maybe we can take her on a turn. I don't have a lot more. I don't know how much redirect he's going to have, and I still have a few topics I want to cover.
Okay. So why don't I bring her in? Well, you posed a question, answer the question. You might need to
Yeah.
rephrase it again for him.
If I recall correctly, I believe this was the second phone call that I had with her, and if it was the second phone call, then that's when it was mentioned about the disorderly conduct.
But your letter here specific says, I have not had to think about or reference the citation since it was dismissed, thus forgetting all about it, the citation, until Tina Verhagen reminded me of it when she said it was the reason they were withdrawing their offer on March 6, 2019, via phone conversation. That's what you wrote,
Yeah.
correct?
Yes,
And I'm trying to figure out if that's an accurate statement.
I believe so.
So then she did tell you
She,
it was the disorderly conduct citation that was the reason the offer was being withdrawn.
yes,
And that
yes,
happened on
that is,
March,
yeah, yes, that is correct.
that happened on March 6th of 2019.
Yes,
Did she also tell you on March 6th that it was the fact that you failed to disclose the disorderly conduct citation that was the reason the offer was being withdrawn?
yes,
So it wasn't the existence of the disorderly conduct citation, it was the fact that it wasn't disclosed.
yes,
Told you. And that all happened on March 6th.
yes.
What additional information did Tina Verhagen share with you during the second conversation on March 8th? As far as the reason the offer was being rescinded?
I'm sorry, can you repeat your question one more time, just so I can get this all straight here?
Your second conversation with Tina Verhagen by telephone on March 8th, 2 days later, What additional information did Tina tell you during that conversation as far as the reason that your offer was being withdrawn?
For the reasoning, she mentioned a judge of character.
Did she explain that it was your failure to disclose the citation that reflected poorly on your character?
Yes.
We can take a break here if you want to bring in Miss Imig.
All right, let me do that.
Can we take like a 3-minute break just to get some water and
Sure,
go to the boys' room?
sure.
Thank you.
I'll bring her in just to let her know that we're gonna be bringing her in, but you guys can take your break.
Okay, and what do you think, Your Honor? And are we doing like 5 minutes or so, 3 to 5 minutes here?
Sure. Hi, Attorney Imig. We were just taking a short break. But we're going to get to you next. I appreciate you waiting for us to get to you. So we're just taking about 3 to 5 minute break, and then we'll come back and we'll get your testimony.
Okay.
So Attorney Formella, I don't know if you can still hear me, but if you want to mute yourself, if you're going to be talking to your client, you can go ahead and mute and then just unmute when we come back on then.